The Attorney General himself, Ken Paxton, tweeted saying, quote, "What we just witnessed is illegal."
Conventional wisdom was we would never get any Republicans to support gun legislation, period.
Anti-gunners put in there to keep the guns out of the hands of lawful citizens in New York State.
Distribution of 10 to 40 million of these braces and the implementation of your rule. Did Congress pass a law?
I'm just inspired by the next generation. I think it's a time for a big change.
It's hunting season in America, and for once, the ATF has become prey. Gunning for it are the Republicans, the powerful gun lobbies, and a large slice of the common American turned gun enthusiast. What's it all about? For the Biden administration and the Democrats supported by American citizens on the other side of the divide, the need for the ATF's gun brace rule is paramount for the safety of the common, hard-working Americans who are asking for just one thing: safety. Sick and tired of being hunted in the streets and schools from gun-toting maniacs who want to make a name for themselves for all the wrong reasons, they have put their weight behind the Biden administration, which has come down hard on American freedom to bear arms. And it seems it has trapped itself in a corner under the combined onslaught coming its way from the courts and gunslingers. So why do they choose to pick up such a huge gauntlet, you might ask? A bleak history. Parkland. February 14th, 2018 was a black day for America. On that day, 19-year-old Nicholas Cruz opened fire on students and staff at Marjorie Stoneman Douglas High School in the Miami suburban town of Parkland, Florida, United States, slaying 17 in cold blood and injuring 17 others.
Blatantly denying the power grab being carried out by the executive branch yet again.
The uptick in violence has just been astronomical. The gun violence.
As a kid, I came out of a different movement, the civil rights movement.
Who showed up here said one thing that felt good about doing this kind of event was that they felt empowered.
Pretty clear about the extent to which this is an abuse of the Administrative Procedures Act.
Is it a difficult question to understand?
I'm sure it's enormously high.
It's 36 per 100,000 people.
I just felt that I needed to be able to protect myself.
Cruz, a former student at the school, took his sweet time on his witch hunt at the school, prowling its halls like the angel of doom and picked his targets one by one. How was he able to show such accuracy as he conducted his manhunt? He shot several of his victims single-handedly, his firearm aided by a brace. He fled the scene on foot by blending in with other students and was arrested without incident approximately 1 hour later in nearby Coral Springs. Police and prosecutors investigated a pattern of disciplinary issues and unnerving behavior. So how did this unstable young man end up with fatal firearms? Apparently, the ball was dropped by somebody. This incident set off a chain reaction in the United States, which pitched the entire state apparatus against the Constitution, the courts, the lobbies, and American citizens. Slaying spree was the most fatal at a high school in United States history, surpassing the Columbine High School shooting that snuffed out 15, including the perpetrators, in Colorado in April of 1999. The incident came at a period of heightened public support for gun control that followed similar incidents in Paradise, Nevada, and in Sutherland Springs, Texas in October and November 2017. Fighting an enemy at the gates. The Parkland incident set off a wave of anti-gun sentiments within the states. Students at Parkland founded Never Again MSD, an advocacy group that lobbies for gun control. On March 9th, Governor Rick Scott signed a bill that implemented new restrictions to Florida's gun laws and also allowed for the arming of teachers who were properly trained and the hiring of school resource officers. President Trump vowed to overhaul some of the nation's gun laws, promising to, quote, do more to protect our children. The president announced a string of changes, including a ban of so-called bump stock devices which can make semi-auto rifles fire like mash guns, and were found on firearms used in that October shooting in Las Vegas. Mr. Trump said that the Justice Department was reviewing the issue and would soon move to take the device off shelves. But at the time, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, the Justice Department agency leading the legal review of bump stocks, had reached no such conclusion. Officials in the Bureau's press office appeared surprised when first asked about the president's comments, and said the agency was still determining whether it could ban the devices, which it had previously said it could not do.
And having to tell her that other 9-year-olds were just killed in a shooting is horrific.
Get on the ground now!
I'm a federal agent.
917-110-3.
I'm a federal agent.
Get on the ground!
Field background checks could stop a lot of illegal guns going in different places in the country.
This shall not be infringed, and the word infringe means by banning parts on firearms actually is against the Constitution.
Affect us here
And it was such a breath of fresh air for the Second Amendment people.
It takes extraordinary courage for them to stand up here and retell the story.
Anti-gunners put in there to keep the guns out of the hands of lawful citizens in New York State.
Mr. Trump's remarks had the desired effect. The Justice Department and ATF aligned themselves with the president, backing away from the Bureau's earlier conclusion and announcing that the agency could ban bump stocks under current law as the president had promised. The steps set off a firestorm of opposition from gun enthusiasts and Second Amendment protectionists. The reversal was the culmination of weeks of political posturing from Mr. Trump, whose public demands have repeatedly short-circuited his administration's regulatory process and at times contradicted his own Justice Department. The Las Vegas incident. Las Vegas Village was a 15-acre lot used for outdoor performances, became famous for all the wrong reasons. From 2014 onward, the venue hosted the annual Route 91 Harvest Country Music Festival. The 2017 festival ran from September 29 to October 1 with over 22,000 attendees on the final day. Stephen Paddock was a 64-year-old former auditor and real estate businessman who had been living 80 miles northeast of Las Vegas in a retirement community in Mesquite, Nevada. Interestingly, he was a son of Benjamin Paddock, a bank robber who was on the FBI's most wanted list between 1969 and 1977. Paddock's only recorded interactions with law enforcement were traffic citations. Paddock was a high-stakes gambler, had lost a significant amount of his wealth over the previous 2 years, but had paid off all gambling debts before that fateful day.
We are not finished. We are not finished. We are not finished.
The submitted firearm brace, when attached to a firearm, does not convert that weapon to be fired from the shoulder and would not alter the classification.
Not one more! Not one more! Not one more!
Distribution of 10 to 40 million of these braces and the implementation of your rule. Did Congress pass a law?
Paddock arrived at Mandalay Bay on September 25, 2017 and booked into room 32-135, a complimentary room on the 32nd floor. On October 1, 2017, he opened fire on the crowd from the balcony of his room, indiscriminately spraying bullets into the concert-goers attending the music festival. From his 32nd floor suites in the Mandalay Bay Hotel, he fired more than 1,000 bullets, slaying 60 people and wounding at least 413. The ensuing panic brought the total number of injured to approximately 867. About an hour later, he was found lifeless in his room from a self-inflicted gunshot wound. The motive for the massacre is officially undetermined. After the Las Vegas shooting, public pressure grew to enforce restrictions on gun possession and sale. Justice Department and ATF officials privately stuck by their earlier conclusion that they could not outlaw bump stocks, but with little appetite to tackle gun policy in Congress, the ATF was asked to review its determination.
To run enhanced background checks on young people under 21 trying to buy a firearm.
This government can protect its own people, except for 36 out of every 100,000 for murders.
Types of disputes that would be settled by people yelling at each other, maybe engaging in a fist fight, are being settled with guns.
I'm just inspired by the next generation. I think it's a time for a big change.
Since you rewrote the rules of asylum based on the perceived degree of violence in these countries.
Selling more guns in the last 3 weeks than we did in the last 8 months.
But for me, and for most of you, here's what it really is. It's an important first step.
When somebody bump fires, think of this as a bump fire stock and able to move.
To be clear, this wasn't based on violence. This is based on threats, specifically to individuals, on gangs.
Buffalo grocery store. A sustained rise in gun violence across the United States in 2022 spurred law enforcement officials and lawmakers to push for more gun control measures. The rule President Joe Biden signed into law was the first major gun safety legislation passed in decades, which was one legislative measure, a part of a series of steps to tighten security. The measure failed to ban any weapons, but it includes funding for school safety and state crisis intervention programs. Many states, including California, Delaware, and New York, have also passed new laws to help curb gun violence, such as regulating untraceable ghost guns and strengthening background check systems. The year 2022 was the second highest year of mass firearm incidents in the United States on record. Though the country saw 692 mass incidents in 2021, years 2022 and 2023 proved it to be child's play.
Today, we say more than enough. We say more than enough.
No Democrat has ever tried to get anybody's guns. I mean, that's just a lie that they tell, and y'all ought to stop perpetuating the lie.
We can reach compromise on guns. We ought to be able to reach compromise on other critical issues, from veterans' health care.
To have their firearms, which are being held by the government, transferred to a third party for the third party to sell.
Atlanta, Buffalo, Uvalde. And for the shootings that happen every day in the street that are mass shootings we don't even hear about.
On March 27, 2023, a mass school slaying occurred at the Covenant School, a Presbyterian church in America, parochial elementary school in the Green Hills neighborhood of Nashville, Tennessee. Aiden Hale, a transgender man and former student of the school, took the lives of 3 9-year-old children and 3 adults before being shot by 2 Metropolitan Nashville Police Department officers. It turned out that it was only the beginning of a brutal year when just a month later, on May 14, 2023, another mass incident occurred in Buffalo, New York, United States, at a Tops Friendly Market supermarket in the East Side neighborhood. 10 people, all of whom were black, were slain and 3 were injured. The shooter, identified as 18-year-old Peyton S. Gendron, livestreamed part of the attack on Twitch, but the livestream was shut down by the service in under 2 minutes. Gendron was taken into custody and charged accordingly. It was clear that America had a problem, and the state reacted by renewing its efforts to clamp down on freedom of firearm use. So it seems the state has an airtight defense for its decisions to enforce stricter gun control, right? Well, not so fast. Let's take a look at the other side of the coin.
I don't really see the purpose of letting other people that don't really know what harm they can do.
You specifically said that.
But I said...
That's the law. What does mandatory mean?
I'm trying to say that...
Does it mean that prosecutors get a choice?
I would expect to see in the coming months and years is a lot of focus on whether or not enough places are deemed sensitive right now.
The Attorney General himself, Ken Paxton, tweeted saying, quote, "What we just witnessed is illegal."
Constitutional freedoms under attack. Proponents of gun freedom have some pretty valid points within the arguments they present in support of their opposition to the ATF rules. They beseech that self-reliance is one of the crown jewels of the American spirit. Before the mass production of firearms, the practice of self-manufacture was correctly understood as belonging to the natural right of self-defense. That the right of self-manufacture is among the natural rights that came under explicit protection when the Second Amendment was adopted. Technological changes don't change the rights of the common people, and the American people still have a constitutionally protected natural right to craft and customize guns. They consider the latest proposed rules as tools of suppressing those rights, especially through the use of misleading terms like ghost guns. The intent of these rules is to tarnish the good reputation of peaceable citizens who have dedicated themselves to helping others be self-sufficient and confident in their abilities to defend themselves. They consider the latest rules as concessions by President Biden, the Department of Justice, and the ATF designed to dramatically exceed their authority and violate congressional intent. In particular, the final rule addressing the definition of frame or receiver and identification of firearms alters the legal landscape surrounding firearms regulation, giving complete discretionary power to the ATF and the director. They can decide what the ATF can regulate and how. As such, the ATF is usurping Congress's legislative power and is wielding the regulation to severely burden the practice of self-manufacture and the business that facilitates it.
So the third party can either keep them in trust or sell them and give the money to Mr. Henderson.
James commented on the decision, saying she's pleased. Remember, the law as it stands strengthens requirements.
And in many cases, the value of the firearms can be quite high.
Today, for the most significant law to be passed since then, since the last 30 years.
And prohibits guns in sensitive places and requires background checks on all ammunition purchases.
Statute means what it says. It says that a convicted felon cannot possess a firearm.
I'd like to thank the leaders and members of the House and Senate for working together to get this done. I especially want to thank the families.
It doesn't say he can't sell a firearm that the government is possessing on his behalf.
They further contend that the final rule violates the First Amendment as well under the new regulations. The ATF would be allowed to assess the content of instructions, guides, and marketing materials of gun parts to determine if a product is a firearm. The issue with such a process is that instructions, guides, and marketing materials are all covered under the First Amendment as speech. The final rules review process would be tantamount to content-based and speaker-based restrictions on speech by a government agency. ATF interpretation of frame or receiver. The Gun Control Act of 1968 regulates firearms in interstate commerce. Among other things, the act requires manufacturers and dealers of firearms to have a federal firearms license. Dealers must also conduct background checks before transferring firearms to someone without a license, and they must keep records of firearm transfers. The Gun Control Act defines the term firearm 4 different ways. A. Any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. B. The frame or receiver of any such weapon. C. Any firearm muffler or firearm silencer. Or D. Any destructive device. But, quote, such term does not include an antique firearm. Congress delegated authority to administer and enforce the act to the Attorney General. The Attorney General, in turn, delegated that authority to the Director of the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF. In 1978, ATF promulgated a rule interpreting the phrase frame or receiver. The rule defined the frame or receiver of a firearm as, quote, that part of a firearm which provides housing for the hammer, bolt, or breech block, and firing mechanism, and which is usually threaded at its forward portion to receive the barrel. That definition remained in place until 2022. In April of 2022, ATF published a final rule changing, among other things, the 1978 definition of frame or receiver. ATF split the phrase into two parts, assigning the term frame to handguns and the term receiver to any firearm other than a handgun.
Because he doesn't care about separation of powers either.
The Texas House of Representatives just voted to impeach Texas Attorney General Ken Paxton.
How many guns has the ATF lost? I'm not sure I understand the question.
But what is also true is that it is incumbent upon the United States Congress, the House of Representatives in particular.
Twime says the Missouri law exposes people to greater harm by interfering with the federal government's ability to enforce firearms regulations.
The extent to which this is an unconstitutional violation of our Second Amendment rights,
such as rifles and shotguns. ATF then defined the terms frame and receiver along the same lines as the 1978 rule, though with updated, more precise technological terminology. But ATF did not stop there. The final rule took effect on August 24, 2022, further explaining thus: 1. The term frame means the part of a handgun or variants thereof that provides housing or a structure for the component, designed to hold back the hammer, striker, bolt, or similar primary energized component prior to initiation of the firing sequence, even if pins or other attachments are required to connect such component. 2. The term receiver means the part of a rifle, shotgun, or projectile weapon other than a handgun or variants thereof that provides housing or a structure for the primary component designed to block or seal the breech prior to initiation of the firing sequence, even if pins or other attachments are required to connect such component to the housing or structure. Rather than merely updating the terminology, ATF decided to regulate partial frames and receivers. Under the new final rule, quote, the terms frame and receiver shall include a partially complete, disassembled, or non-functional frame or receiver, including a frame or receiver parts kit that is designed to or may readily be completed, assembled, restored, or otherwise converted to function as a frame or receiver. But, quote, the terms shall not include a forging, casting, printing, extrusion, unmachined body, or similar article that has not yet reached a stage of manufacture where it is clearly identifiable as an unfinished component part of a weapon, for example, unformed block of metal, liquid polymer, or other raw material. When determining whether an object is a frame or receiver, the ATF director is not limited to looking only at the object. The final rule also amends ATF's definition of firearm to include weapon parts kits. The ATF's new definition of firearm shall include a weapon parts kit that is designed to or may readily be completed, assembled, restored, or otherwise converted to expel a projectile by the action of an explosive.
Conventional wisdom was we would never get any Republicans to support gun legislation, period.
Are ones where, in fact, it's most likely that they should be bringing the highest and mandatory minimum.
Details of the law, but folks, listen at home. Here's a quick summary of what this law is doing. It's already allowing.
Demonstrating that blind loyalty to Speaker Dade Phelan is more important than upholding their oath of office.
Might end up being a message amendment because the President of the United States will almost assuredly veto it.
Vanderstock versus Garland. Clearly, the people felt that boundaries had been overstepped, and the answer was a lawsuit which landed in the American justice system. The decisions coming out in the Vanderstock versus Garland lawsuit are considered landmark decisions which have come out to protect the rights of American citizens from a protectionist state's draconian steps, encroaching upon the Constitution. So, what was it all about? Jennifer Vanderstock and Michael Andrin are Texas residents who own firearms. Vanderstock is a high school teacher and former police officer. Andrin is a licensed firearms instructor and retired aerospace administrator. Both Vanderstock and Andrin own firearm components that they intend to manufacture into firearms for personal, lawful use. They claim that the final rule prohibits them from purchasing products that they want to use to manufacture their own firearms. Tactical Machining LLC manufactures and sells items that are subject to regulation under the final rule. Over 90% of Tactical Machining's business consists of selling items that individuals can use to manufacture frames and receivers and to build functioning firearms. The owner and CEO of Tactical Machining says the company had to cease sales of those items after the final rule took effect. Tactical Machining estimates that cessation of over 90% of its sales will put it out of business. In addition, Tactical Machining's freight company now refuses to ship most of Tactical Machining's products because the company fears the parts may be considered firearms under the final rule. Tactical Machining's credit card processing company has likewise threatened to stop providing services to Tactical Machining, which does 95% of its sales through credit card. The Firearms Policy Coalition Incorporated is a nonprofit organization dedicated to promoting the Second Amendment rights of American citizens through legislative and legal advocacy. The plaintiffs, Vanderstock, Andrin, Tactical Machining, and the Firearms Policy Coalition sued the Attorney General, Department of Justice, ATF, and the ATF Director over the final rule. The case. These parties came together to move for a nationwide preliminary injunction to prevent ATF from enforcing the rule. They argued that the final rule is unlawful because it, 1, exceeds ATF's statutory authority under the plain language of the Gun Control Act, 2, is a major question that Congress did not delegate to ATF, 3, is not a logical outgrowth of the proposed rule, and 4, represents a drastic, unexplained change in ATF's position. The plaintiffs say enforcement of the final rule will likely put Tactical Machining out of business. The parties briefed the issues and the motion was ripe for review. The legal standard. A preliminary injunction is an extraordinary remedy and will be granted only if the movements carry their burden on all 4 requirements.
That requirement for showing a heightened need for self-defense, that was the teeth of these permitting laws.
And within less than 15 minutes, you can walk out the front door here with a rifle or a shotgun.
American citizens in places like New Orleans and Baltimore and St. Louis begin to seek asylum in countries like Honduras and Guatemala.
I don't know if you're referring to any particular incident.
The court issues a preliminary injunction only if the movements establish 1, a substantial likelihood of success on the merits, 2, a substantial threat of irreparable harm, 3, that the balance of hardships weighs in their favor, and 4, that the issuance of the preliminary injunction will not disserve the public interest. The last 2 factors merge when the government is the opposing party. In such cases, the movement must make a clear showing that the injunction is warranted, and the issue of a preliminary injunction is, quote, to be treated as the exception rather than the rule. Analysis of the arguments. The plaintiffs showed a strong likelihood that they would succeed on the merits of their claims that ATF's new definitions are inconsistent with the Gun Control Act. The Administrative Procedure Act requires courts to, quote, hold unlawful and set aside agency action, findings, and conclusions found to be in excess of statutory jurisdiction, authority, or limitations. ATF has exceeded its boundaries. Firstly, the plaintiffs argued the final rule exceeded ATF's statutory authority under the Gun Control Act in 2 ways. 1, plaintiffs argued that the final rule expands ATF's authority over parts that may be readily converted into frames or receivers, when Congress limited ATF's authority to frames or receivers as such. 2, plaintiffs argued that the final rule unlawfully treats weapon parts kits as firearms.
Because they like the outcome of the policy, the banning of a piece of plastic.
Post-Bruin challenges have succeeded in lower courts. The opinions and reasonings therein have been grossly mischaracterized.
Obviously they're gone, but it will be an inspiration for us to do more. I'm not going to sign this bill into law.
Circuit decision in U.S. v. Rahimi is worth highlighting. As others have noted, the panel struck down a federal statute.
The Gun Control Act. it's clear that the parts that may become receivers are not receivers. The text of the Gun Control Act resolves this motion when, quote, the statute's language is plain, the sole function of the courts is to enforce it according to its terms. Congress carefully defined its terms in the Gun Control Act. The primary definition of firearm in the Act contains 3 parts. Quote, any weapon, including a starter gun, which 1 will or 2 is designed to, or 3 may readily be converted to expel a projectile by the action of an explosive. Under this primary definition, a firearm is first and foremost a weapon. Interpretation by Congress. Underscoring that point, Congress explicitly named starter guns in the definition because starter guns are not obviously weapons. Then, because weapon parts are also not weapons, Congress created a secondary definition covering specific weapon parts, the frame or receiver or any such weapon. Congress did not cover all weapon parts, only frames and receivers, and only the frames and receivers of any such weapon that Congress described in the primary definition. Congress did not define the phrase frame or receiver, so the words received their ordinary meaning. Whereas in the final rule, ATF interprets the phrase as 2 separate parts. ATF says the, quote, term frame means the part of a handgun that provides housing or a structure for the component, i.e. sear or equivalent, designed to hold back the hammer, striker, bolt, or similar primary energized component prior to initiation of the firing sequence. ATF defines receiver similarly, though it says the term refers to a, quote, rifle, shotgun, or projectile weapon other than a handgun. Plaintiffs do not take issue with those definitions, which appear to be updated, more precise versions of ATF's 1978 interpretation.
I don't have a gun, but I don't give a damn about anybody else having one.
The most serious readily provable offenses in cases where mandatory minimums are present because it's not warranted.
Giving domestic violence abusers a license to kill and essentially preventing the government from doing anything at all about it.
What changed is that item that was submitted was not produced and was not the item that was marketed.
The government quite properly charged him with several crimes.
The sensitive places doctrine was not at issue in this case and still exists.
But then it released him, apparently believing that a civil restraining order instead of pretrial detention was the best way.
He went on to say he looks forward to a quick resolution in the Texas Senate.
Predictably, Mr. Rahimi soon thought, to hell with your restraining order.
Who are prepared and carry a gun oftentimes have to make split-second decisions.
Aggravated assault with a deadly weapon against a different woman using a gun that he wasn't legally allowed to own, but obtained anyway.
But the final rule did not merely update ATF's terminology. ATF added an entirely new section, expanding its jurisdiction to include, quote, partially complete, disassembled, or non-functional frames or receivers. ATF now claims authority to regulate parts that are designed to or may readily be completed, assembled, restored, or otherwise converted to function as a frame or receiver. These parts must be clearly identifiable as an unfinished component part of a weapon. In deciding whether something is a partially complete frame or receiver, ATF may consider other materials such as molds, instructions, and marketing materials that are sold, distributed, or possessed with the item or kit. The final rule's redefinition of frame or receiver conflicts with the statute's plain meaning. The definition of firearm in the Gun Control Act does not cover all firearm parts. It covers specifically the frame or receiver of any such weapon that Congress defined as a firearm. Congress could have included firearm parts that may readily be converted to frames or receivers, as it did with weapons that may readily be converted to fire a projectile. But it omitted that language when talking about frames and receivers. Likewise, when Congress uses a phrase in one part of a definition and excludes that phrase from another part of the very same definition, courts should give effect to Congress's deliberate exclusion. ATF expanded the definition. Congress excluded other adjectives that ATF adds to its definition. The final rule covers disassembled and non-functional frames and receivers. Congress's definition does not. Again, compare the language in Congress's primary definition of firearm includes any weapon that is designed to fire a projectile. That language covers disassembled, non-functional, and antique firearms because they are designed to fire projectiles even if they are practically unable to do so. But Congress wanted to exclude antique, so it explicitly said the term does not include an antique firearm. In contrast, Congress did not choose to cover firearm parts that are designed to be frames or receivers. That is, incomplete, non-functional frames or receivers, and that omission is telling.
That Bruin is a thing from which the public must be protected. This is simply not true.
So other families will not have the experience and the pain and trauma that they had to live through.
For too long, states like New York told millions of citizens that their right to armed self-defense ended the moment they left their homes.
She proves you can run for office ending gun violence in the South and you can win.
Lawful gun owners are not the driving force behind criminal gun violence, and this is particularly true of concealed carry permit holders.
AK-47 is an automatic Kalashnikov model of 1947.
At the same time, as I outline in much greater detail in my written submission, they play a significant but underappreciated role.
You can prevent the next tragedy. You can save life. You can save families in the process.
ATF's new definition of frame or receiver is facially unlawful. By comparison, the final rule includes definitions of frame and receiver that appear to be consistent with the statute. This further highlights that the final rule's expansion of authority to firearm parts that are not yet frames or receivers goes beyond Congress's definition. ATF's expansion, on the other hand, covers additional parts that are designed to or may readily be completed, assembled, restored, or otherwise converted to function as a frame or receiver. It is purely an expansion of authority beyond the statutory language. Too much power to the ATF. To be sure, ATF is entitled to deference on its expertise in determining whether a particular component is a frame or receiver. There are no doubt close calls, as illustrated by the samples tactical machining has sent to ATF over the years, but this does not require the court to determine how much machining is necessary to transform a component into a frame or receiver. That determination lies with ATF. Rather, the issue here is whether ATF may still regulate a component as a frame or receiver even after ATF determines that the component in question is not a frame or receiver at the time of evaluation. Congress has not extended ATF's authority so far that the firearm part is designed to be or may one day become a frame or receiver does not change the fact that, in that moment, it is not the frame or receiver of any such weapon. Arguments from the defense. Firstly, defendants found fault with the plaintiffs for adding words to the statute. Defendants argue that plaintiffs read the phrase frame or receiver to mean complete frame or receiver or functional frame or receiver. That argument poses two problems. First, the issue here is one of kind, not of degree. An incomplete receiver may still be a receiver within the meaning of the statute depending on the degree of completeness, hence the industry term 80% lowers. But the final rule treats incomplete receivers that are not yet receivers as if they were receivers under the statutory definition, which is clearly a step too far. Second, defendants' argument adding language to Congress's definition is inappropriate, then the final rule is unlawful on that ground alone. Defendants next argue that plaintiffs' interpretation thwarts congressional intent. According to defendants, quote, the clear congressional intent was to regulate as a firearm the frame or receiver of a weapon. That much is evident. But defendants jump from that premise to a boundless congressional intent to define firearms more broadly than a fully operational weapon. They further clarify that the regulatory goals of the Gun Control Act were narrower. The act ensured that weapons were distributed through regular channels and in a traceable manner and made possible the prevention of sales to undesirable customers and the detection of the origin of particular firearms. The question of the parts. Plaintiffs are also likely to succeed on their claim that the final rule unlawfully treats weapon parts kits as firearms. The final rule contains its own definition of firearm, notwithstanding that the Gun Control Act already defines the term. ATF has no general authority to regulate weapon parts, but the final rule grants ATF that general authority by copying language used throughout the statutory definition. It takes phrases like designed to and may readily be converted and assembled from various places in the statute, cobbling them together to form ATF's own definition of firearm. Those terms may add a patina of credibility to the drafting, but they tarnish Congress's carefully crafted definition. More importantly, they unlawfully expand ATF's authority beyond the boundaries set by the Gun Control Act. The only firearm parts that fall under ATF's purview are, quote, the frame or receiver of any such weapon that Congress defined as a firearm, but the final rule regulates weapon parts kits, that is, aggregations of weapon parts, that are designed to or may readily be completed, assembled, restored, or otherwise converted to expel a projectile by the action of an explosive. Congress's definition does not cover weapon parts or aggregation of weapon parts, regardless of whether the parts may be readily assembled into something that may fire a projectile. The statutory context repeatedly confirms that Congress intentionally chose not to regulate weapon parts generally. The Gun Control Act's precise wording demands precise application.
Inventing the pistol stabilizing brace to help his friend, a disabled combat veteran, at the shooting range.
You gave testimony that the brave ATF agents are the ones showing up at 2 a.m. after a burglary.
Do any of my colleagues on the other side of the aisle give a whit about separation of powers?
Connecticut delegation, which is incredible. I think on this issue and many others, you're the best delegation in the United States.
No guns were lost. They were stolen by an individual who's now in prison.
And of course, we've got a lot of criticism over this. So why is it not a machine gun?
In areas that are poor, mostly minority, there's a mass shooting.
Congress wants to change the law and come up with a new interpretation, then ATF will follow that new interpretation.
The definition of destructive device also includes any type of weapon that may readily be converted to expel a projectile by the action of an explosive or other propellant, and which has any barrel with a bore of more than 1/2 inch in diameter. For example, suppose a manufacturer tried to sell a parts kit to make a homemade grenade. ATF could regulate that parts kit because it can regulate any combination of parts either designed or intended for use in converting any device into a grenade, from which a grenade may be readily assembled. But commonly sold firearms such as 9mm pistols or .223 rifles do not fall under the specialized definition of destructive devices, so weapon parts kits for those firearms cannot be properly regulated as components of destructive devices. Defendants argue the final rules regulation of weapon parts kits is consistent with existing judicial interpretations of the Gun Control Act. To the contrary, the cases demonstrate that courts understand the constraints of the Gun Control Act's definitions. The only Fifth Circuit case defendants cite held that a disassembled shotgun was still a firearm under the Gun Control Act's definition. The plaintiffs prove irreparable harm. Tactical Machining has shown a substantial threat of irreparable harm. Tactical Machining's owner says that he will likely be put out of business by the final rule. That claim is not far-fetched. Over 90% of Tactical Machining's business consists of producing and selling items that customers can use to self-manufacture frames or receivers and to build firearms. The final rule, as defendants admit, quote, requires Tactical Machining to become a federal firearms licensee and comply with regulatory requirements, such as keeping transaction records and marking firearms with serial numbers. Tactical Machining's fears have also proven well-founded. On August 24th, when the final rule took effect, Tactical Machining ceased sales of various parts. Because ATF now classifies those parts as firearms, Tactical Machining may not sell them directly to consumers out of state. As a result, just last week, Tactical Machining lost nearly $50,000 in revenue. This trend risks ending Tactical Machining's business. Defendants argue that Tactical Machining can avoid loss of its business by simply complying with the rule, which was easy and cheap.
Yes, good faith applications of Bruin will likely result in some favored gun control laws being struck down.
Thought it just like, wow, it doesn't fit the definition, it doesn't fit the rulings, but we better run this up the chain.
To the extent that Bruin threatens certain laws, however, these are generally laws that weren't very good at protecting the public in the first place.
Some months later, during an ATF audit, I was told the background check was now a non-approval.
At the same time, it's undeniable that Bruin does not threaten many of the laws that are most effective at protecting the public.
The Fifth Circuit has settled these principles. First, the circuit has explained that substantial financial injury may be sufficient to show irreparable injury. Second, compliance costs are likely unrecoverable. Issuance of an injunction. On 3 March 2023, an injunction was issued in the case which sent a shockwave of elation throughout the rank and file of the opposers. The decision was issued by Judge Reed O'Connor for the U.S. District Court for the Northern District of Texas, Fort Worth Division. His preliminary injunction applies to Defense Distributed and its clients. Judge O'Connor agrees that ATF's final rule expanded the agency's authority over parts that may be readily converted into frames or receivers, which surpasses the authority granted by Congress. Even more compelling is that the judge agrees that ATF's rule unlawfully treats parts kits as firearms.
In June of 2021, you changed the department's asylum rules so that it could apply to individuals with significant gang violence.
Most apparent here, a defense of the Second Amendment, which this most certainly is.
Wyme says the Missouri law exposes people to greater harm by interfering with the federal government's ability to enforce firearms regulations.
We can expect in the future that more people will be carrying handguns on the streets in places like Los Angeles, Boston, and New York City.
As many of you out there, either parents, relatives, and/or victims yourself,
To do anything about what the president is doing to exercise that authority unconstitutionally, as was the case with student loans.
Because people buy hundreds of guns legally and then they sell them illegally.
Final nail in the coffin. A federal judge vacated the ATF final rule a few days ago on the contention that changed the definition of what constitutes a firearm under federal law in the United States. The big takeaway here is that the U.S. Congress passes laws that agencies are entrusted to enforce, not to redefine as they deem appropriate. The court vacated the final rule, bringing an end to a saga. How the establishment reacts to that, only time will tell. And that's all that we have for you today, folks. Join us next time at the next one.